Ladies and gentlemen, thank you for taking the time to be with us today and welcome to the M&A Masters program, our seventh one this year. My name is Prasanjit Chakravarti and I am a partner in Ketan's corporate and M&A team. I would like to extend a very warm welcome to this webinar to everyone of you, whether you are in India or you have tuned in from abroad. The M&A Masters program is designed to be a very sophisticated, educative, and discussion-oriented program on contemporary M&A issues uh, for experienced corporate executive, in-house legal teams, investment banks, intermediaries, and other relevant M&A stakeholders. Our subject today is M&A disputes in review. On this slide is the agenda for today's webinar. We'll just give half a second to pop it up. Yeah, there you go. Uh, if you have any questions during the webinar, you please feel free to use the facility provided in the portal and share your questions. If we cannot cover all the questions, rest assured we will respond to you separately after the webinar is done. And we will, as always, send you a copy of the presentation which my esteemed colleagues will present today, along with the summary notes and the recording of this webinar. Uh, Now, introducing this topic today, which is really a very important topic for all of us, because today's webinar sits at the heart of corporate law and business strategy, because it focuses on disputes in M&A. When M&A deals go wrong, now, of course, we all know that mergers and acquisitions are pivotal in driving growth, accessing new markets, restructuring business, etc. However, the complexity and high stakes in these M&A transactions often lead to disputes that can be both challenging and expensive. Understanding how to navigate M&A disputes is very essential for developing successful M&A strategies and successful outcomes. Our approach to today's topic is a practical one. In this webinar, we will examine two landmark Indian M&A cases and explore the implications of those cases for those involved in M&A. Each of our distinguished speakers will present one case study each, offering deep insights into the key issues involved and lessons to be learned. These real life and world examples will provide important lessons for all of us to learn and get a good understanding of the practical implications of M&A disputes and the lessons they offer. While obviously the past may not necessarily hold true or always be a good basis to predict the future, these cases provide a very valuable and unique opportunity for learning in M&A at no cost. Now, as you can see on the screen are my esteemed panelists and the two expert speakers today. Uh, all of you who have registered for this webinar would have already received by email a summary of Ravitej and Sneha's credentials. So I will not spend time to reiterate them. Suffice to say that both Ravitej and Sneha are experts in this subject matter and are extremely well qualified to express views and opinions on M&A disputes. So I think without further ado, why don't I hand over the forum to first Ravitej, who will present on one of the most landmark cases in recent times, the Zee-Sony merger. And then after that, I will invite Sneha to talk about the Amazon future dispute. So over to you, Ravitej. Thank you.
Thank you so much, Prashanjit, and thank you everyone for joining us in today's webinar. I will be talking about an M&A transaction and the subsequent dispute that sort of came out of it, which has been in the news for the last couple of years. The Zee-Sony merger was to be the landmark deal in the India media space. with two of the biggest media conglomerates joining hands, and was designed to have a broader impact in the general global entertainment industry. Um, the disputes sort of were ongoing in multiple forums, including an arbitration before the SEAC tribunal, which I believe is pending. Of course, those are confidential proceedings, and a lot of what we have today is basis publicly available information. But with that, we've sort of tried to demarcate a bunch of issues that cropped up in this dispute from an M&A standpoint and otherwise, ranging from corporate governance issues in fact, in both the companies, to non-fulfillment of conditions precedents allegedly by both parties, and eventually we also sort of see the issues that came out of the contractual arrangement between the parties with respect to termination fees, etc., and of course third party actions which also at some point took center stage, which with actions by institutional investors, shareholders, etc. The companies in question obviously need no introduction. It's Z, which is obviously operates in the space of television, print, internet, mobile content, etc., and Sony, which sort of is one of the leading players in the sports and entertainment space, including with the streaming platform that they have. Of course, as you can imagine, a merger between two companies of this size was, of course, the talk of the town from the day it was announced. On September 21, the board of Z sort of gave its in principle approval to the merger, and what was to come out of it was a behemoth in that sense, with a proposed valuation of about $10 billion. And eventually, an agreement called the Merger Cooperation Agreement was entered into in December 21, and they sort of set a 2 year period by which they wanted this deal to sort of end, and the end date was December 2023. And there was a 1 month long discussion period sort of post the end date. Um, that was sort of the buffer in case the merger was not implemented by then. And as in any similar agreement of this kind, there were obviously conditions precedents that both parties had to fulfill within that time period. And should the transaction not have fructified, there was an approximate $90 million termination fees. And one of the things agreed at that stage was that Puneet Goenka was to lead the combined entity as CEO and managing director. Now, of course, over the next 2 years, while both companies were sort of going through the rings to get their approvals from stock exchanges, the competition commission, the NCLT, etc., there were a fair amount of hurdles that sort of came in the way, and the first of which started with Invesco, which was an institutional investor in C. What they did was they requisitioned for an extraordinary general meeting and sought the removal of Puneet Goenka as the CEO and managing director of Z as it stood then. And this action was just before the merger cooperation agreement was signed. And they also sought sort of the appointment of 6 new independent directors. This requisition was, of course, rejected by Z, and this led to a round of litigation both before the NCLT and the Bombay High Court, and several months sort of went by. Eventually, yes, the requisition was withdrawn by Invesco. But while Invesco never opposed the merger per se, it sort of did leave a fair amount of question marks over the corporate governance of C and the manner in which things were moving. And it would be no surprise that that definitely would have had some impact on Sony's thought process as things moved as well. Simultaneously with this, sometime in about a few months after the merger agreement was signed, one of the lenders took Z to NCLT to initiate CIRP, and which eventually got settled at the MCLAD stage, but not before there was an admission per se at the NCLT stage. And of course, along with that, to further make matters difficult, SEBI issued show cause notices against the promoters and other directors of SL Group entities, alleging diversion of funds, siphoning of funds, etc. So, and of course, there were other lenders also who initiated debt recovery actions and CLT actions against Z. So all of this sort of played out in the two-year period that was set for the parties to complete the conditions precedents, etc. Of course, at this point, presumably Sony may have gotten a bit nervous about things, and we understand that there were also discussions around looking at appointing someone else as the CEO and managing director of the combined entity, which of course Z sort of was not agreeing to. And I think that may have been one of the reasons things sort of came to a standstill, and that's where legal proceedings between the two sort of started. And the first issue that sort of came up at that point was that the end date, as I mentioned earlier, had come to an end. The month long discussion period had also passed. And Z, of course, at that stage sought to extend the end date, but Sony didn't agree. And eventually, Sony terminated the MCA and initiated arbitration proceedings at the SEAC, seeking, I'm sure, among other things, the termination fee of $90 million. It also sought to seek an appointment of an emergency arbitrator to prevent Z from approaching the NCLT for the implementation of the merger. The emergency arbitrator, and fairly predictably, ruled that it did not have jurisdiction to restrain Z from availing statutory remedies that it had, and in that sense didn't grant that interim relief. And on the back of which Z filed an application before the NCLT to seek implementation of the merger. There were other shareholders of Z which also filed similar applications. And interestingly, Z also eventually withdrew that application and terminated the MCA, citing breaches on behalf of Z, on the part of Z. So we essentially then see that the MCA is terminated by both parties, and obviously there'd be claims on both sides. And that sort of set the ground for what it was to become and the eventual fall of the transaction per se. Now to sort of move to the key issues and takeaways. Um, First and foremost was, of course, the entire corporate governance concerns that came up. This dispute definitely highlighted significant governance issues within Z, which became a central focus during the merger discussions. And more prominent concerns revolved around the leadership and management of Z and the role of the promoter family, etc. There were allegations of financial improprieties, regulatory investigations, etc, and of course the failure to maintain transparency, accountability, etc., etc. All of which obviously then highlighted the importance of due diligence in transactions of this nature, and not just financial due diligence, but also a diligence on the company's governance practices, leadership integrity, regulatory compliances, etc. And it emphasized the need for clear, enforceable governance structures, independent boards, and transparent communications with shareholders. Um, the contractual disputes between Z and Sony then sort of played a significant role as well in the collapse of the merger. The first being the issue around the extension of deadline in the implementation of the merger. This is not the first time in an M&A dispute in India that this issue has come up. It came up in the Max Healthcare Quality Care transaction as well. And again, this sort of, with there being a disagreement of sorts on the issue of extension, I think it sort of highlighted that it becomes absolutely necessary to lay down in clear and unambiguous terms the end date for the implementation of the merger, as well as the procedure for an extension should the need arise. The other issue, obviously, which is again a fairly important issue in M&A transactions, is termination fees. And termination fees generally, we've started noticing in transactions, is not just to protect the buyer or the seller, it's actually to protect both, to sort of uh, in some ways hold the parties accountable to each other in the transaction and not sort of run away from it. But here we had a situation where both parties claimed breaches of conditions precedents, and therefore both sides are sort of claiming termination fees, presumably. This again are issues we've seen in merger transactions globally, including in the AT&T and T-Mobile case, where uh, while it was the US regulators that sort of didn't give the go ahead to the deal, T-Mobile still had to, AT&T still had to pay out termination fees um, for the failure of this merger. So that's the other issue that came up, and of course, fulfillment of conditions precedents will become a significant part of the dispute between the parties, given that both parties claim that the others sort of failed to meet their obligations under the agreements. And And from what we understand from the disclosures made by the parties, both are claiming termination fees on account of failures on the others to fulfill these CPs. Apart from obviously the whole issue that arose with between the parties, there were, as I mentioned earlier, this dispute is significant because there was a fair amount of third party actions that took place, including shareholder actions. There were um, there were shareholders who approached the NCLT to sort of get the merger go through. Sony opposed them, saying that look, they do not have any locus to sort of interfere. And while a decision on that sort of didn't really come in hard words, but the NCLT sort of did indicate that any member can apply to the NCLT to question workings of an arrangement, etc., in terms of Section 230 and 232 of the Companies Act. So that's another sort of route that took as well. We perhaps may not see too much coming out of those, given that both parties have terminated the MCA, but it'll be interesting to just keep an eye out on those. Of course, what didn't come through here and perhaps would not come through is disputes that could have arisen post implementation, because we have seen situations play out where parties post the implementation of mergers have made claims against the other, citing issues of fraud, misrepresentation, etc. The Daiichi Ranbaxy issue being one of the more famous ones. So while we probably will not see that come through, those still were issues that could have played out if things were to move, um, and yeah, it would have been interesting to see the outcome of that, because those are again typical in M&A disputes where the implementation of a merger per se does not mean that things have come to an end, but the saga sort of goes on. So I think that's largely what's happened in the Zee-Sony merger issue that sort of eventually fell through. And again, like I said in the beginning, it makes for a very interesting study because of corporate governance issues that surrounded it, contractual disputes between the parties, but more importantly, the number of stakeholders that got involved in litigation around it, from institutional investors to shareholders to others. So I think it's sort of, and of course the lenders. So I think it's an interesting dispute to follow, and it obviously gives teachers a lot of valuable lessons in terms of what we need to do to ensure that this doesn't get repeated, with transparency, etc. Being and proper diligence to be at the forefront of that. So that's my take on this. Thank you for listening. Hope you found this useful. And if you have any questions, as Prasenjit said, there is a box for you guys to put in the questions as and when you do, and I'm happy to take those questions. Thank you, and over to you, Prasenjit.
Thank you, Ravitesh, for this marvelous presentation. I think I at least have two immediate follow-up questions for you. I think while the audience puts their question, I think first question is, I can see on the screen and what you mentioned that there were basically parallel proceedings, multiplicity of proceedings, even third parties getting involved. Now, is it fairly common in a bilateral dispute for so much clutter which will come in terms of proceedings between parties as well as third parties, or is it kind of aberration? What's your take on that?
Look, you know what I sort of did see happen, and this is something that again we've seen in multiple shareholder disputes, is everyone tries and throws the kitchen sink at the other. When the intent is to sort of stall something, you would approach the NCLT, you would approach High Court if you could, you would approach a tribunal if you have that recourse. And we've also seen instances where there are certain, you perhaps find the set of shareholders to oppose if you don't want to be in the forefront of that. So we've seen all of that play out. And it's not unusual that we're dealing with a situation where multiple people have sort of initiated litigation with lenders, with the parties to the agreement, shareholders, etc. And that is fairly common, I feel, especially now when the intent largely is to sort of negotiate a settlement rather than to see through a dispute. I think we've seen parties sort of taking all recourses, and then of course now with several other statutory recourses also available through regulators, SEBI, etc. Like even in Zee-Sony, we've seen that, right? SEBI was taking action. People were going to the NCLT under the insolvency code. There was arbitration proceedings. There was emergency arbitration proceedings. So yes, we are seeing a fair amount of that, and that's not very unusual.
Right. So I think again both parties should be careful that if you throw a punch, there will be some retaliation and all kind of actions one should be open to. I think the second and I think a very critical question, Lavitej, is that as at the outset I mentioned that for the audience, one thing is to of course know about this landmark dispute, but what are the key lessons to take away from so that when parties are stitching a M&A deal together they don't fall into the same pitfalls and they can learn from this kind of a dispute and really kind of get ready so that they don't make these mistakes. So what are some of the key pointers as per you which party should keep in mind when negotiating a similar transaction?
Right. So, Prashant, this is a very interesting question actually, and as I was saying towards the end of my presentation, that this dispute sort of ended up highlighting a lot of governance issues which had earlier not come up. And it became one of those issues where corporate governance issues within the entity sort of came in the forefront, and I think that's why, as I said earlier, of course, you can never predict which way a deal is going to go, or do enough to mitigate litigation. But of course, I think strong due diligence of not just, as I said, financials, but also regulatory practices, etc., is important, especially in a deal like this, where it was a merger of two very differently run entities. It's important that parties are transparent. It's important that there's free flowing information being shared. There's transparency with shareholders. There are disclosures that are made properly, and of course, you can never stop a lender or anyone litigating against you, but you can definitely keep the communication channels open, transparent, clear. Perhaps that could have helped, and I think that also sort of, that coupled with good corporate governance practices, and transparency, I think those things sort of become very critical, because documentation, watertight agreements are things that are anyway happening. They've happened over the years. But what this sort of highlights is the need for something beyond just lawyers sitting and stitching an agreement together. It went far deeper. It went into personalities of people. It went into the way organizations were running. And I think that's something that one must sort of factor in while trying to stitch a deal of this kind.
No, I completely agree. I think it's one thing to have a watertight agreement, but how do you conduct and the obedience in spirit and letter, both the agreement, I think is so critical by both parties. I mean, whether you party X or party Y, the buyer or seller. So I'm absolutely in full agreement. So I've got a bunch of questions, but you know what I will do? I will take this up from the audience questions at the end for the half an hour we have earmarked. Let me now kind of invite Sneha to come in and talk about, well, another landmark case, the Amazon Future Retail Dispute. Sneha, over to you for the next 12 odd minutes to run through your presentation, and then we head towards the Q&A.
Thank you, PC. Thank you, Ravitej, for that amazing summary on the Zee-Sony dispute. So I'm going to attempt to follow that act up. So the dispute that I'm going to be dealing with is the Amazon future dispute, which has had a lot of press attention over the last 2 years, given the scale and the nature of parties involved. So before I get into what the legal issues were and what is relevant for parties in M&A transactions to bear in mind, let me just set the stage in terms of what the broad deal terms were and what were the timelines. Now, the acquirer in this case, of course, was Amazon Investment Holdings LLC. And the seller was the Biani Group, who were the promoters of the future retail enterprise. Now, the interesting thing here is because foreign direct investment to a substantial extent was not permitted in multi-brand retail sector, Amazon, which was actually interested in the retail assets, which was held by Future Retail Limited, could not have invested directly in Future Retail. So what did the parties do? They entered into a two-tiered contractual mechanism. So there was a primary shareholders agreement at the future coupons level, to which Amazon was a party and had special rights in terms of consent requirements by future coupons in disposal of any retail assets in respect of its shareholding in future retail. And then a second level agreement at the future retail level, to which future coupons was a party and Amazon wasn't, under which also future coupons had special rights in respect of disposal of retail assets by future retail. Now, pursuant to these special rights that accrued to Amazon through the dual transaction structure, it proceeded to make an investment of about 1,400 crores and acquired a 49% stake in the target, which in this case primarily was future coupons and not future retail. So the key elements really of this transaction was that the investment would ultimately flow down to the retail entity, which is future retail, for control rights to be given to Amazon. That was really the heart and soul of this transaction. And accordingly, this investment flowed in December of 2019. Could we switch to the next slide, please? So what did transpire in this transaction post that? Now, what was the contractual scheme? Like I mentioned, so in August 2019, you have two levels of shareholder agreements and subscription agreement. In December of 2019, you have the investment coming in. But interestingly, the future group was saddled with a huge liability and debt in 2020 of about 17,000 crores. So they decided to hive off all of their wholesale and retail assets in logistics and warehousing business to the Reliance Group. Now, another interesting element of the shareholders' agreements was that there was a restricted set of entities to which future retail could not have sold their retail assets, one of which was the Reliance Group. So the moment this transaction was put in play, Amazon, of course, invoked arbitration under the shareholders' agreements and triggered an emergency award from an emergency arbitral tribunal in a SIAC-seated arbitration. What is important to note that is that both the shareholders' agreements at the future coupons level as well as the future retail level had similar arbitration clauses, which had India-seated arbitrations governed by SIAC rules. The emergency arbitrator passed his award in October 2020, restraining the future group from proceeding with obtaining any approvals for conclusion of its transaction with Reliance Industries. However, Future took a position that the emergency award is a nullity and it continued to obtain regulatory approvals. In fact, in January 2021, it obtained CCI approvals, it obtained a SEBI approval, and consequently, Amazon was constrained to approach the Delhi High Court to seek an enforcement of the emergency award passed by the Emergency Arbitral Tribunal in SIAC. So the Delhi High Court, a single judge in February and March of 2021, passed orders recognizing that the emergency award is actually akin to an interim order under the Indian Arbitration Act, and that Future would have to abide by it. In fact, the High Court went so far as to pass sanctions against the promoters by attaching their assets and asking for their presence in aid of a request for detention. These orders, of course, were appealed before the division bench of the High Court, which stayed them, and ultimately the proceedings came up before the Supreme Court in August of 2021. Now, sadly, for better or for worse, this transaction has today not proceeded to conclude because of a lack of approval from the secured creditors. But it pulled up some very interesting issues that came up for determination for the very first time, two of which I will be dealing with in the course of this presentation. Next slide, please. So the first issue that really is interesting that got flagged up is the group of companies doctrine. Now, this is something that the Indian courts have been grappling with for a very long time, with not necessarily the level of clarity required, and it played a fundamental role in regulating the decision of the emergency arbitrator, which is what was sought to be enforced. Now, what did the emergency arbitrator do? So again, just by way of a recap, this transaction was structured in two layers. So there was the FCPL SHA, to which Amazon was a party, but Future Retail was not. And the retail assets were really sitting with Future Retail. And the second level of the transaction was the FRL SHA, to which Future Retail was a party, but Amazon, the ultimate investor to whom those rights accrued, was not a party. So the only way for both parties to be bound by a common award was for the application of a group of companies doctrine by the emergency arbitrator. So what is this doctrine really? What the group of companies doctrine does is recognize the fact that companies forming part of the same group are essentially distinct legal entities, but they can be bound by the agreement to arbitrate even if they have not signed up to it as a signatory. Now, what is the basis on which the court can hold this to be the case? So, typically, and this has been clarified by the Supreme Court even as recently as in a Cox and King's decision of this year, which is that the entirety of the transaction is taken into account. What is the relationship between the parties, the signatory and the non signatory? What is the composite nature of the transaction? What is the subject matter of the transaction? Ultimately, who is affecting performance of this transaction? Now, all of these factors were taken into consideration by the emergency arbitrator. What did he find when he really dissected this transaction? He saw that there was a clear interlinking between the FCPL shareholders agreement and the FRL shareholders agreement. The agreements were negotiated simultaneously at both levels. Both of the parties were well aware of the special rights that were being accrued to Amazon ultimately, and the transaction really had a common intention, which was the flow of the special rights to Amazon ultimately, and therefore also had common and similar dispute resolution clauses should a dispute arise at any level. And on this basis, the arbitrator went on to apply the group of companies doctrine and pass injunctive orders that restrained Future from going ahead with the transaction with Reliance, which was a restricted entity under the shareholders agreement, which would have directly breached the special rights that accrued to Amazon. So this was one critical issue that formed the basis of the award. And this was the award that was brought ultimately by Amazon to the Indian courts for enforcement. Now, what did the Indian courts do in the enforcement proceeding? Next slide, please. So, as far as enforcement of emergency awards were concerned, courts in India had, before this decision in Amazon, not expressed a clear view. Sorry, could we move to the previous slide? Thank you. So before I proceed to clarify what the court really went on to hold, what is an emergency arbitration really? An emergency arbitration really is a fast track process where you can seek an urgent interim relief from a tribunal before your actual arbitral tribunal is constituted. So typically for parties who are used to arbitrating their disputes, which is very common in M&A transactions, it takes a typical time of about 8 to 10 weeks from when the notice of arbitration is issued and responded to for a tribunal to actually be constituted, especially if it's a three-member tribunal. And if you are in an M&A situation where assets are going to be dissipated, as was the case with the Amazon dispute, if they didn't get immediate injunctive reliefs and regulatory approvals came through, there would really be nothing left to protect. What institutional rules do, and this is common across multiple institutional rules like the ICC, the LCIA, the SIAC, and in this case, the SIAC was the applicable rules, is they allow you to approach an emergency arbitrator who's basically an ad hoc arbitrator appointed in the interests of giving you urgent interim relief if it is called for, to seek a protection of the rights. So this becomes very, very critical, especially if you're dealing with jurisdictions that aren't very commercially advanced. So this is what was triggered by Amazon in this case. Now, when this matter approached the Delhi High Court, while the Delhi High Court, the single judge upheld the award, this was stayed by a division bench who disagreed, and it ultimately came up to the Supreme Court for decision. Now, Amazon's position really was the statutory scheme in India does not recognize expressly an emergency award, and they are right. But what did the Supreme Court find? The Supreme Court found that while the statutory scheme may not have expressly used the words emergency arbitration or recognized it, there is absolutely no bar against such an award. In fact, an emergency award is akin to an interim order that is passed by an India-seated arbitral tribunal. And again, in this case, it's relevant to bear in mind that the seat of the arbitration was in India, which is why this was possible. So it is solely in such instances with institutional rules that are permissive of emergency arbitration that an emergency award passed by an India-seated tribunal is enforceable in India. But again, it's relevant to flag, and in fact, extremely critical to flag that if that is not the case, if the arbitration is not seated in India, and you are dealing with an emergency award of a foreign seated tribunal, India still does not have a statutory scheme in place that will allow for a direct enforcement. So parties in such a scenario may be better off actually approaching an Indian court under a statutory scheme, which is essentially what has been held by various decisions of the Delhi and Bombay High Court. For parties who are familiar with the scheme of the answer trial rules, jurisdictions like Hong Kong and Singapore have actually made express provisions in their statutory schemes that allow for direct enforcement of such foreign awards passed by emergency tribunals. This is missing in the Indian scheme. So until that lacuna is really fixed, that is not an option available to parties. So this is something that parties will need to bear in mind. So ultimately, what are the two key takeaways that we have from this decision? Next slide, please. So, two things emerge really. One is the group of companies doctrine is really a conduct and consent based doctrine. So, what does that mean for parties entering into a transaction? It's important to recognize whether you are a party who would rather benefit from having either your group entities or the counterparty's group entities being bound by a common arbitration agreement, or whether you are the party who would benefit from having a ring fenced agreement. If the latter, then you need to make sure that performance is affected by the entities contracting alone and that your arbitration agreement is clearly ring fenced to ensure that non signatories are not made a party to it. But again, you will also have to ensure that performance is really only affected by parties to the contract. The second point to bear in mind is that as far as emergency arbitrations and their enforceability is concerned, if this is a remedy that you are keen to explore, then you need to ensure, as far as enforcement in India is concerned, that you seat your arbitration in India and you adopt rules that permit you to have this kind of a remedy enforced in India. So these are two points that are critical to bear in mind and can make a big difference in terms of your immediate reliefs. Thank you so much for your time and patience in listening. Over to you, Prasanjit.
Thank you, Sneha. I think you mentioned a tough act to follow after Ravi Tej's presentation. I can tell you've done a remarkably good job. I think before we dive into the audience questions, one, Sneha, two follow-up questions from your presentation. I think about this decision in this particular case, what does it really mean in a broader perspective for the enforcement landscape in India?
Sure, Prasenjit. So for a jurisdiction as broad as India, smaller jurisdictions like Singapore may be a different ballgame altogether. But we are a very large commercial jurisdiction. So some of our state courts are sort of better equipped to deal with interim relief petitions under the statutory schemes. Like, for example, the Delhi and the Bombay High Courts do a remarkably good job of this. But maybe if you're saddled with an older contract that has a jurisdiction elsewhere in India, you're going to be struggling with a statutory remedy from a court in a timely manner that's of any use to you. So, in this kind of a situation, at least having the institutional process of an emergency award available to you and enforceable before an Indian court can be a very, very big tool. And I think that is something that this decision went a long way to clarify and provide some amount of confidence in.
Right. And the second question, Sneha, is the same one actually I asked Ravi Tej. Is again multiplicity of proceedings and all that third party. So again, what's your take? Is it in your experience also common and one should brace up for this kind of kind of chaotic litigation process when this kind of disputes blow up?
Oh, absolutely. In fact, I think just to keep things streamlined, I haven't touched upon a lot of the lateral disputes that were ongoing in Amazon before the NCLT, the independent directors of Amazon, sorry, the Amazon writing to independent directors of future, raking up issues of conflicts of interest. So a lot of lateral litigation has happened, and this is par for course in an M&A transaction, whether you are the party who has breached the contract or the party who wants to enforce the contract. And I can't agree more with Ravi Tej in that, the throw the kitchen sink approach is very, very prevalent. And parties should, especially in high stakes disputes like this, expect the counterparty to avail of all remedies available to them to achieve their end goal. Depending on the facts, whether you want to be the party that's going to trigger all of those remedies, or the party that has to defend those remedies is another issue. And interestingly, the scheme of our statutes are such that different fora are equipped to provide different remedies that don't necessarily overlap. So, in that sense, it's not a situation where parties are forum shopping necessarily. So, that adds another layer of complexity to the litigation strategy.
Right, very insightful. So I think enough of my questions. I think now let's take audience questions. I think I can see a whole host of questions. And this is actually a lot of these are not related to the presentation, but actually M&A disputes in general. I think first immediately Ravitesh one is connected to the presentation. They is that how realistic are disputes of this magnitude likely to be settled? Is it realistic, or is it something which always basically are diffused by the court or tribunal? What's your take on that?
As I said, Prasenjit, a short while back, that a lot of um, people throwing the kitchen sink is eventually not to litigate them out, but to get people on the table. And interestingly, and just today, you would have seen news of the Sony Z deal potentially getting settled. There were disclosures made just today that parties are going to eventually withdraw their claims for termination fees and try and settle. So, I think that itself tells you that there's this whole saga of litigation. People have been fighting for months, shareholder action, lenders, and the world, and eventually, we are at a situation where we're hearing news that this dispute is also settled. So I think a lot of litigation strategy sometimes is driven towards getting issues resolved or settled. Not always, but sometimes. And we are sitting on a live example right now. So yeah, I think it's the timing is
No, I
interesting.
Yeah, no, I completely agree. In fact, many of the M&A matters, whether it's on account of MAC or other issues, I have seen going to dispute. After the temperature kind of boils down, I think eventually parties know that they have to get on with their lives, right? And I think instead of litigating for 5, 7 years, let's say, they might as well arrive at a win-win solution and move on. So I think you're absolutely right. I think settlement is another discussion point for some other day, but it's a very important issue to resolve disputes, I would say, amicably at the end of the day. Now, I think the second question again, Ravi, just first I will go to you. This is an interesting one, that why do some parties in M&A deals, are obsessed with foreign law to govern their M&A agreements and foreign dispute resolution mechanism? Uh, when I say foreign, non-Indian, basically governing law, UK governing law, SIAC arbitration, LCIA, both. So, what's this fascination with foreign laws and foreign arbitration proceedings?
And as litigation lawyers, and I think Sneha will agree, so much of jurisprudence over the last few years in arbitration has come out of how did the parties actually agree to litigate. So before you even actually fight the dispute, you're fighting over what's the substantive law, what's the seat, where is it going to be, what's going to apply. I think everyone around, I think it's an obsession. I mean, excuse me for saying this, but I think it's an obsession of corporate lawyers to sort of complicate these dispute resolution clauses sometimes, and that's where this whole obsession of what should be the governing law, what should be this and that sort of come into play. But I think the key here is you have a very simple dispute resolution clause drafted. In terms of your choice of law, I think the things you need to consider are the nationalities of the two parties. Where are they residing? Where is the dispute likely to arise? As in, where is the cause of action likely to arise? Where is it that you'll eventually take the award to enforce? I think these are the factors you need to consider, and they all become important. For example, as Sneha spoke about the Amazon future thing, the whole concept of an emergency award factors plays in on your choice, right? Because Singapore seated emergency award is potentially not directly enforceable in India versus a Delhi seated emergency award by SIAC itself. So I think, and the kind of dispute that future Amazon had, and given the cause of action, I think it was a very smart choice to sort of pick at that at the negotiation stage that India should be the seat of arbitration. So I think a lot of the discussions around this stems from an inherent bias against litigating in India because of the stories some people may have heard in the past. Though I'm more optimistic about it, I think the way the both the Commercial Courts Act as well as the Arbitration Act has sort of evolved over time. Things are moving quick. We are of course seeing resolutions. We are seeing things sort of play out. So I think the variables need to be kept aside, and the choice needs to be determined on, as I said, nationality, cause of action, where you're likely to enforce.
Right, and if I may add, Ravita, is that even if you choose for foreign law, you can't derogate from substantive laws of India like income tax law, foreign exchange management act. So while at times parties may want to play safe, as you said, because of the past experience or perception, bear in mind there's still going to be challenges and bottlenecks. So I think, and you can't really avoid Indian laws in that sense. Moving on to Sneha. Sneha, I think this question is about what disputes commonly arise in relation to breach of representations and warranties in Indian M&A transactions and how these can be mitigated.
Sure, Prasenjit. So typically we see rep and warranty disputes across a whole gamut, ranging from title to shares to regulatory disputes. In fact, in the recent past, regulatory disputes has been a very big chunk of a lot of the M&A disputes that we're seeing, or even at the diligence stage, the kind of concern that parties raise in the regulatory disputes has been huge. And of course, accounting disclosures, financials are some of the other key points. In fact, one of the most recent and most high-profile cases, which Ravitej also mentioned, was a Daiichi breach of rep and warranty, where they were accused of underplaying the FDA violations, which resulted in inducing Daiichi to invest. And the award was granted to them not on the basis of an indemnity, but on the basis of a breach of Section 19 of the Indian Contract Act, which deals with misrepresentation. And that award was upheld and enforced by the Delhi High Court. So, really, what you're looking at here is a breach resulting in a damages claim. But typically, what we do tend to recommend as practitioners for regulatory breaches is specific indemnities. If you do know that there are big concerns that are going to crop up, or you don't have sufficient visibility on the nature of the concern, either walk away from the deal if it's big enough, or if you need to do the deal, then make sure that you have specific indemnities in place. And I'll tell you why. There's a big difference under Indian law in the way damages and indemnities are treated. Damages require causation and remoteness analysis. So if the counterparty can resist your claim on the basis that it's not a direct loss or that it was not a foreseeable loss, you're going to go through that second hoop in proving your claim. Whereas if you set up an indemnity for a known risk, it doesn't matter whether it's a direct or indirect loss. You have a right to claim it and you're protected financially. So that's typically what we tend to advise in terms of protections. And this is largely the kind of rep warranty disputes that we see, and increasingly more on the regulatory side.
Right. So that's very helpful. Ravi, there's coming to you again. Question around contracts in M&A. How do disputes arise from MAC clauses, material adverse change clauses, in Indian M&A, which basically governs the between signing and completion any material changes? What kind of disputes you see, playing out?
I think we saw a whole host of them, a flurry of them around COVID-19 and the onset of COVID-19. I think it's sort of that issue sort of became like was the in thing at that point, and we did see some ourselves. And typically, how things started out was, say for instance, you put your price bid early 2020, and you obviously were taking in, say, I'll give you an example of a deal that we were doing, and they were in the steel space, and X amount was the bid that our clients had put in for that entity, and documentation sort of moved fairly smoothly in February. Obviously, things paused in May, and April, our client comes back and says that, look, uh, there's been a material adverse change. This entire onset of COVID-19 affects industries, affects manpower, affects the steel market in general. And they sort of tried to, help. I mean, they asked us to try and sort of get them to wriggle out of this. And there, what we noticed is, and this is again jurisprudence that sort of did come in from various courts in India at that time, is you will have to analyze the contract. You can't make a claim for force majeure. You can't make a claim for material adverse change in thin air. It has to form basis in the contract. And unfortunately, and read with law, a lot of people never predicted this, right? Which obviously, in that sense, is act of God, but they never factored that into the definition. So we saw several clients that unsuccessfully tried to get themselves out of Mac. But that did teach us a very valuable lesson, which is that when you're drafting those clauses, you obviously try and factor things in to cover for every eventuality. Uh, but interestingly, what we did also see is there were instances of fair trade, and with a fair amount of valuation expert help, we did in one instance actually renegotiate a deal with one of the purchasers who fairly, without really there being an explicit requirement in the contract, did renegotiate the deal as a basis of that. And and I think it's again it comes down to the same thing that there needs to be proper intent and synergies and communication between the two entities involved in a transaction. If that is there, I feel I have seen where sort of things did get renegotiated and things sort of did come through. But having said that, I think that the law on that is pretty clear. We need to word our agreements very well to sort of cover for eventualities. And if it's not there, if we are looking at a litigation scenario, because uh, there will be a mismatch of thought process, and I would assume courts would tend to sort of lean on the wordings of the agreement specifically to sort of adjudicate on whether there can be an exit renegotiation or enforcement as a result of MAC clauses.
Yeah, not absolutely. I think I was also on the receiving end of some of this, COVID related Mac, and of course the way we now define it, things like pandemic and have become a very common feature. Whether to exclude it, not exclude it, at least there's a debate around that.
Yeah.
And very important to draft it again in a, very clear manner. I think one more question.
Interestingly, in the last couple of interestingly, in the last couple of months, last year or so, we're also seeing act of war being fleshed out a
Yeah,
lot more.
of course. Yeah,
Um,
yeah, of
it's
course,
the
of course. I think with the current situation, yes, it's a very relevant, I would say, event. Uh, I think it's a question. The next question I think is perhaps is directed at me, but I will open it to both of you also. This is from Aradhya Kaushal. How effective would it be to limit liabilities in M&A deals, and if the parties do decide on an amount to which they limit the liabilities to, like the cap, how it is held up in courts? So I think my 2 cents, Aradhya, is that see, any limitation you put in terms of liability is a contractual affair. So I can limit my liabilities to X amount because that is, as we were talking, indemnity is a contractual provision. So I can limit my liability in a contract. The only exception would be that if it's vitiated by fraud. So if you suppress material facts, suppress material information, and then claim refuge under caps and limitations, that may perhaps be difficult to enforce in a court of law because your own hands are unclean. But barring that, if you have limitations, it's absolutely contractual matter, and courts normally don't reopen contractual terms entered between private parties. You agree with that, Avijit Sneha? Broadly, that I think should hold up in court of law and arbitration, right? Limitations.
Yeah, I think that's what we fairly see.
Hmm.
Yeah, absolutely. Just one point to add to what you said, PC, is that how you word that, like you rightly said, how you word that clause becomes extremely relevant. So, in a lot of cases, if your clause is so worded that it's your contractual rights that are getting capped, as litigating lawyers, we tend to get creative. So we bring up tortious claims, right? We bring up claims on negligence. We bring on claims of indemnity that aren't necessarily capped. So be careful about how you word it. If you word it broadly and well, of course, it'll hold up, but these are sort of some of the loopholes to be aware of.
Yeah, no, that's a very good point, Sneha. Just to close the loop. So typically from seller side, what we always mention, the seller side, mind you, that indemnity is the sole and exclusive monetary remedy. So they cannot file multiple suits of damages and whatnot and come after the poor seller. I'm advising for the seller, I'm saying. So and of
Yeah.
course as buyer you want the exact opposite, that I can come after indemnity, damages and whatnot. It's a matter of negotiation, but absolutely spot on points, Sneha. uh, the next four questions, Neha, is for you only. Actually, I think it's this is what challenges are there for foreign parties enforcing foreign judgments, arbitral awards in an M&A dispute, and how can parties prepare for these?
Okay. So let me segregate that into two buckets. So foreign judgments can be a whole different ballgame from foreign awards. So foreign judgments typically require reciprocity in terms of conventions at the international level for recognition and enforcement. So unless a judgment is from a reciprocating territory that is recognized by the Indian government, they aren't generally enforceable directly, so you will have to relitigate in India. So when you're opting for foreign jurisdiction clauses, not arbitration clauses, please beware of that. For example, some of the most common queries that we deal with is our, judgments from the US enforceable in India, and they're not directly enforceable because we see, of course, a lot of M&A transactions involving US funds and parties. So that's something to bear in mind. Arbitration, on the other hand, is a completely different ballgame. So typically, parties that are a party to the New York Convention, their awards, as long as the awards are passed in one of those states, they're enforceable. And most of the leading commercial jurisdictions are parties to the New York Convention, and they're enforceable. There is, like Ravitej was mentioning earlier, some level of bias, or whether well informed or not, in terms of how Indian courts tend to deal with foreign awards. The good news is that that's improved by leaps and bounds in the commercial jurisdiction. So, in terms of pitfalls for a party that's looking to enforce, really, it's far more limited today. The outlook is definitely far more progressive. So, unless your award really has a blatantly perverse public policy issue to India, it's unlikely that an Indian court is going to want to interfere. I realize that there is some amount of skepticism given the DMRC judgment that came out recently, but really that's an outlier. It's very rare for the Indian Supreme Court, after 4 layers of review, to actually, in the fifth layer, set aside an award. Typically, the approach of courts is pro enforcement, it is pro arbitration. Uh, Interference is very, very limited unless you can show something egregious, like a party not being allowed to lead its case, evidence of a party not being considered, something that's fundamentally that goes to due process. Typically, courts don't interfere. So that's on the enforceability side. And on the timeline side as well, yes, we may not be as quick as a Singaporean court, but we're getting there very, very quickly. The enforcement timelines are really going down on a day on day basis. The commercial courts in India are actually getting up to speed. They're getting digitized, they're getting up to speed, they're being sensitized on commercial matters. And that is a diktat that's flowing through from the lowest commercial court to the Supreme Court. So that looks on the upside as well. So I think, all in all, fair prospects of enforcement in India.
Yeah, so I think heartening news for our foreign clients watching this. I think it's not as bad as it's sometimes made out to be. I think the process is improving and accelerating. Uh,
So, sorry to
Ravikesh,
cut you off, Peter. Just one instance on that. Now that we've come to this, and this is a quip that a lot of us like to share because it's an outlier. So, in one of the largest awards that we had for a client, which is a 1 billion award, which could have been enforced in the US, the UK, and India, where of course we were the most skeptical, or the client was the most skeptical about enforcement in India. We filed parallel proceedings in all three jurisdictions, and we got an enforcement order in India in 6 months, while the other two jurisdictions hadn't even started the process. So it can be very effective if you have the right commercial court.
there you go. I think so. It could be preferred option actually, to the contrary of not being a preferred option. So that's great news. I think, Ravitesh, the next question is, it's a question which I at least get asked all the time in every deal I do. That corporate lawyers fight tooth and nail on indemnities. Now, it's one thing to have a clause, then, but when you actually, let's say there's a payout to be made pursuant to indemnity clause, uh, how the enforcement goes, as far as from courts and arbitration standpoint is concerned. If somebody dig their heels in, how do you really enforce the indemnity provision, in the M&A contract?
Look, I think as you rightly said, indemnity is something that is one of the most heavily negotiated provisions in the agreement. Uh, I've had, and there may be some disputes lawyers who sort of disagree with me when I say this, but my experience with indemnity enforcements in the last few years has been fairly positive. Uh, what obviously one has to be careful of while enforcing indemnity provisions is to ensure that the process that the contract has laid down for indemnity enforcement is followed to the T. Uh, of course, there will be counterparties who will come and say that, look, I'm not going to pay, etc. But what we've fairly seen is the party that's giving the indemnity, say in case of a litigation, for instance, uh, they maintain control of proceedings and they sort of do tend to find a way to resolve the indemnity claim that has come through. And in those instances where we've seen indemnities not come through, we've seen multiple approaches work. One is approaching court in a Section 9 application saying that, look, this is very clear, they need to secure me. We've had situations where the Bombay High Court has secured parties on indemnity claims. I'm not saying they've handed the money over, but they've sought deposit of monies that are subject matter of the dispute. Similarly, the other is initiate arbitration and file your application for interim relief before the arbitrator. Again, we've seen arbitrators protected. Uh, because of this narrative that's gone around that indemnity is negotiated very heavily, but eventually getting an indemnity claim is not that easy, parties don't pay. I think arbitrators today are also very conscious of that mindset, and they want to actually enforce available remedies under the contract. And the thing with indemnity is generally that there should not be a fight over this. This is pre-agreed, this is predetermined. You just need to make your claim in the process that follows, and the other party needs to sort of indemnify you. Increasingly now we are seeing that being enforced, so which I think is a positive trend. It's again important that you draft things out in your agreement very clearly. Your disclosure schedules and exception schedules are very clearly defined, should not be vague. To the extent of if it's a litigation, specifying exactly the case numbers, etc., all of that. I think if you're specific with it and a claim does arise out of it, I think you're fairly well covered in your agreement to approach court or an arbitral tribunal to sort of get your reliefs.
Right. So it's not a like kind of a toothless thing. The indemnity, if you draft it well, it will come to your rescue. The only thing I will add, is that Indian foreign exchange law has pricing guidelines. So no matter how well you draft your indemnity, you cannot circumvent that. So I think because there's a cap in terms of fair market value, and that will always be respected by tribunals because that's a separate specific law. So besides those exceptions, I think the tribunals will bail you out as the enforcement party. Uh, I think the next question I will just throw it wide open to both actually. Is it this is from Alvin Selvam? Is it possible for foreign clients to invoke writ jurisdiction in acquisition transactions involving government PSUs on the other side, where an auction or bid process is put in place? So writ jurisdiction in case of auction deals involving government.
So Sneha, do you want to take that or do you want me to?
For
Sure.
foreign clients, yeah.
I mean, either way, Ritesh.
Okay, go ahead. I'll add.
Sure. So yeah, Alvin, good question. So writ jurisdiction typically is not involved for contractual remedies and unless there's a government party involved. But in your case, like the case, the problem that you've put forth is something that involves both, as I understand it. So if it's an auction sale that involves a government entity, then yes, you can invoke writ jurisdiction in this sort of scenario. Of course, you'll have to overcome the maintenance threshold, but there's sufficient law on it to show that if there's a public interest involved that goes beyond your contractual right, or enforcement of your contractual right is not efficacious or quick enough, depending on what relief you need, you can approach a writ court for relief on this.
So this is, and the answer will be same if it's a foreign client, as Alvin asks. It's a foreign client. Does it change anything? The locus of the
No.
client being foreign? Nothing.
No, so the writ jurisdiction is not dependent on the locus of the plaintiff. It's dependent on whether the party against whom you're seeking relief is really within territorial jurisdiction of the court and a government entity. Basically, it has to be state for the purposes of writ jurisdiction. So it doesn't matter if you are a foreign entity.
And just
Very
to
clear.
add to
Okay.
that, because the
Yeah.
question sort of covers for a bid situation, I think again there's enough law to support the fact that generally courts are very reluctant, even especially in a writ jurisdiction, to interfere with bid terms or bid conditions of PSUs. Because the way courts look at it is that that it's the PSU or the government entity is the one that's best equipped to decide who is to bid or what the terms, etc., of bids are. So while there have been several challenges in the past to bid conditions or declaration of successful bidders, courts generally are reluctant to interfere in that, whether it's an Indian petitioner or a foreign petitioner. So I think that's also something to be kept in the back, that writs may not necessarily be the most effective remedy.
Right. So that's a very comprehensive response, Sneha and Ravitej. One more question again. This is from Sunidhi, and again, I also get asked this very often. In your opinion, what is the best for M&A disputes, ad hoc arbitration or institutional arbitration? I know I keep on going back to you guys for this advice all the time. So, what's your take? Again, ad hoc or institution? I know it's tricky answer. It's not as straightforward, but yeah.
Ravi, why don't you go first now,
Yeah,
supplement?
I would never give you a answer to this question because I think
Uh,
it depends on a bunch of factors. If you asked me this question 7, 8 years ago, I would have said institutional because ad hoc is just going to go unending and unending in over years. But not anymore. Things have become quicker. So ad hoc arbitration in that sense is not as untouchable as it used to be. But having said that, I do feel that institutional arbitration offers a slightly better structure. So especially in complex disputes, I would suggest institutional arbitration also because institutes have on their panels arbitrators who perhaps are slightly more better equipped to deal with complex, say, valuation disputes, exit disputes, complex M&A disputes. So I think that's where institutional arbitration does have advantages. Also, in the fact that it's slightly more professionally administered. Of course, that makes a difference. And also, and I don't mean to say this as a hard fact, but we've seen a trend that institutional arbitral awards are generally less interfered with at a challenge stage. I know it's a slightly controversial thing to say, but that's just something, like I said, an unofficial fact that sort of has emerged over the years. But having said that, courts these days are quite, you know, are appointing very experienced people as arbitrators, even in ad hoc situations. So I think it's horses for courses. I think you need to consider the value of dispute. You need to consider the parties involved. You need to consider the issue involved. And I think that's probably where how you probably need to decide whether you go the institution way or the ad hoc way. But not to say that one is an absolute no go. That's my take on
right.
No, I
No, I
think,
think yes, no, go ahead. Yes.
sorry, PC. Go.
Yeah, that's good. Yeah,
No, I think Ravitesh has pretty much covered, most of the bases. Really, also from uh, an M&A deal standpoint, I think parties tend to draw a lot more comfort from the structure that comes with an institutional arbitration, which drives a lot of the recommendation, not necessarily its effectiveness. And he's absolutely right in saying that it's horses for courses, which is the value of your dispute and how comfortable you are with having an ad hoc sort of dispute resolution in place drives a lot of it also. Another thing to bear in mind is really that even an ad hoc India seated dispute, as of today, has a guiding principle of a 2 year timeline for completion. So you're not really looking at a timeline that's very different from what an institutional arbitration would do in this sort of situation. So ultimately, the drivers come down to your comfort in terms of case management, really, and visibility that parties want.
right. So I think I have time for one last question before we go to the key takeaways, conclusion, vote of thanks, etc. And this, Neha, is maybe you can take it. I think again, very pertinent question. What kind of disputes arise in enforcement of non-compete and non-solicitation clauses in M&A transactions? A restriction which is so important for the buyer, so the seller doesn't breach the non-compete and non-solicit. But how does it really stack up in terms of enforcement?
So, non-compete clauses in M&A deals is something we do see pretty often on the enforcement side. Even if it's not litigated, it does go very far in terms of a negotiated settlement. So, as long as goodwill is being transferred, the Indian law does recognize the enforcement of a non-compete in a business to business transaction. So in an employer-employee situation, the regulations work slightly differently than it does in the M&A situations. So there's really two drivers that courts tend to look at. One is there a limitation in terms of the geographical and temporal restrictions on, let's say, a promoter not carrying on the same business? So that has to be reasonable. So it can't be an indefinite timeline or an overly broad geographical restriction. That's something that courts look at. But if that is in place, and you have a clearly defined clause with in a typical M&A transaction, goodwill moving, then courts don't interfere and they do tend to enforce those provisions against the promoters or against the sellers. Now, the other interesting angle in this also comes from a competition standpoint. So while your non-compete may be kosher from a contractual standpoint, that may not be the case from a competition law standpoint if it's really resulting in displacing the market in a manner that is anti-competitive. So the regulator also tends to look at whether your clause is enforceable. So that's the other angle to look at. So even if you have geographical and temporal restrictions, if it is an industry, say, such as alcohol beverages, that has a slightly more restricted playing field, then your clause is going to come under greater scrutiny. So it's also an industry specific adjudication that can make a difference.
Right.
Just on
That. Hmm.
Sorry, just on the non-solicit pieces, again, typically with KMPs and employees, we do see non-solicits being enforced unless you can show that there is an inducement, which is very rare. At least in my experience, I haven't seen too many employees being able to show an inducement. So if the employee voluntarily resigns and joins a competing organization, enforcement of a non-solicit is much harder. Otherwise, they are enforceable clauses under Indian law.
Yeah, no, correct, absolutely correct. And I think uh, the lots of questions, but I think respecting the time, I think we'll respond separately offline, as I mentioned after the webinar. I think before we go to the conclusion part, if I may request Ravitej and Sneha, uh, maybe a couple of takeaways each, very quickly. I know we have discussed a range of issues today through the Q&A and your own presentations. But from M&A standpoint, what are the two key takeaways each, or one takeaway each, which you would like to leave for the audience to stay with them?
If I had to name the first and the most important key is draft your contracts well. I think the devil is always in the details, but at the same time, over complexity is what leads to a lot of disputes. So I think in M&A transactions, the first and foremost thing is have your contracts clearly drafted, lay out each one's obligations well, lay out the timelines well, lay out the trigger events, define them clearly, define your timelines and methods of extending that clearly, define your dispute resolution mechanism clearly. I think just defining things clearly becomes very critical as the dispute sort of evolves, because a lot of disputes get complicated uh, in the detail in the drafting sometimes. So I think it's important that that's taken care of because that's in your control.
Excellent. Couldn't agree more. Sneha?
So, absolutely agree with Ravitesh. Also, I mean, there is always an extensive diligence before, typically M&A is concluded, but do involve your enforcement teams in advance. It can be immensely helpful if you have your disputes teams or your regulatory teams look at your contracts before you sign them, because they're likely to be able to flag. Of course, you're absolutely familiar with what sort of disputes could arise, but they're looking at it on a day-to-day basis, and it could add immense value in terms of avoiding pitfalls. So that is my other takeaway in terms of what you could do better to avoid M&A disputes. Yes, it's going to cost you a penny more before you sign, but it will save you a pound when you go into an enforcement scenario.
No, absolutely, Sneha. And I think increasingly what I am witnessing, clients are appreciating this kind of integration of the advice, even while drafting contracts with like experts like you. and commenting on the governing law, dispute resolution, enforcement. So, because it's one thing to have a clause, but if something is off and then it's of no use, then really, as you rightly said, it will cause more headaches in the future, the resolving headaches. So I think it's something which I am also increasingly seeing as a M&A practitioner, that clients are willing to pay with absolutely no hesitation. I think let's Mitesh or Prajay go to the poll slide now and put it up on the screen. Uh, Before closing, I would like to ask each one of you to respond to this poll slide on your screen, which is here now. Uh, we take this very seriously as part of our continuous improvement program. So we'll just have it up for a minute and then we will head towards conclusion. So I think, in conclusion, firstly, I would like to thank uh, everyone who participated in the poll. Firstly, and also I think to all our presenters, for sharing their expertise and experience with us today. I think it was just incredible to get a practical experience, shared with all of us. I think Ravitej and Sneha, you were simply outstanding, and thank you very much for sparing your time. I know how busy your day-to-day work is, so it's really commendable to spare time for this for the benefit of our audience members. And of course, all this effort we have put together is for our audience only. So thank you very much, our dear audience, for your attention and time and the questions you asked. We hope you found the webinar very interesting and a worthwhile investment of your time. We, of course, as always, thoroughly enjoyed bringing this to you. As I mentioned, we will send across a copy of the slide decks you saw today. We'll send across the recording should you wish to share or review it again, and a summary of whatever we discussed today. You will also receive a separate feedback form separately. Please spare a minute. It will take barely a minute to share your comments, criticism, compliments. Everything is most welcome. If you are interested in in-house training or any other matters arising from this webinar, please feel free to drop us a line and we will consider that. Our contact information is right now on the screen before you. You can reach out to any of us. Before logging off, I thank you once again for your attendance today and look forward to be at service again at the M&A Master Series. Thank you very
Thank you.
much.
Thank you, Prasenjit, for the opportunity. And thank you, Sneha.
Thank you. Thanks,
Pleasure.
everyone.
Thanks, everyone.